Well, good morning, everyone. Thank you all for being here. I'm joined here today by Assistant Attorney General Bill Baer of the Justice Department's Antitrust Division and Assistant Attorney General Leslie Caldwell of the Justice Department's Criminal Division, as well as our partners from the FBI and the CFTC, Assistant Director in Charge Andrew McCabe of the FBI's Washington Field Office and Director Eitan Goldman of the CFTC's Division of Enforcement. We are here to announce a major law enforcement action against international financial institutions that for years participated in a brazen display of collusion and foreign exchange rate market manipulation, and will, as a result, pay a total of nearly $3 billion in fines and penalties. Today's historic resolutions are the latest in our ongoing efforts to investigate and prosecute financial crimes, and they serve as a stark reminder that this Department of Justice intends to vigorously prosecute all those who tilt the economic system in their favor, who subvert our marketplaces, and who enrich themselves at the expense of the American consumer. Now, starting as early as 2007, currency traders at several multinational banks formed a group that they dubbed the Cartel. It's perhaps fitting that they chose that name, as it aptly describes the brazenly illegal behavior that they were engaged in on a near 5-year basis. Almost every day, for more than 5 years, traders in this cartel used a private electronic chat room to manipulate the spot market's exchange rate between euros and dollars, using coded language to conceal their collusion. They acted as partners rather than competitors in an effort to push the exchange rate in directions favorable to their banks but detrimental to many others. Now, the prices the market sets for those currencies influence virtually every sector of every economy in the world. Their actions inflated the bank's profits while harming countless consumers, investors, and institutions around the globe, from pension funds to major corporations, and including the bank's own customers, who placed their faith in the market and relied on it to produce a competitive exchange rate. As a result of our investigation, 4 of the world's largest banks have agreed to plead guilty to felony antitrust violations. They are Citicorp, JPMorgan Chase Co, Barclays PLC, and the Royal Bank of Scotland PLC. These 4 banks have acknowledged their role in this conspiracy and committed to changing their corporate cultures starting at the highest levels. They've also agreed to pay criminal fines totaling more than $2.5 billion, the largest set of antitrust fines ever obtained in the history of the Department of Justice. And the fine that Citicorp alone will pay, $925 million, is the largest single fine ever imposed for a violation of the Sherman Act. These unprecedented figures appropriately reflect the conspiracy's breathtaking flagrancy, its systemic reach, and its significant impact. A 5th bank, Switzerland's UBS AG, has agreed to plead guilty and pay a $203 million criminal penalty for breaching the non-prosecution agreement it entered in December 2012 regarding manipulation of the London Interbank Offered Rate, or LIBOR, a benchmark interest rate used worldwide. The breach of this non-prosecution agreement was based in part on UBS's fraudulent and deceptive currency trading and sales practices related to the foreign exchange markets, and its collusion with other participants in the FX markets, and its failure to take adequate action to prevent unlawful conduct after prior civil, criminal, and regulatory resolutions. In other words, UBS promised in other resolutions not to commit additional crimes, but it did. This represents the first time in recent history that the Department of Justice has found that a company breached a non-prosecution agreement over the objection of that company. But I want to be clear. The Department of Justice, under my watch, will not hesitate to file criminal charges for financial institutions that reoffend, and banks that cannot or will not clean up their act need to understand that non-prosecution agreements and deferred prosecution agreements carry very real consequences and will be enforced. The penalty that all of these banks will now pay is fitting, considering the long-running and egregious nature of their anti-competitive conduct. It's commensurate with the pervasive harm that was done, and it should deter competitors in the future from chasing profits without regard to fairness, to the law, or public welfare. Now, today's resolutions are a testament to the tireless efforts of the Antitrust Division's Criminal Enforcement Section, the Criminal Division's Fraud Section, and the FBI's Washington Field Office. I want to thank all of the agents, prosecutors, law enforcement officials, and analysts who contributed their time and their talents to achieving these remarkable results. I also want to express my deep appreciation for the cooperation and the assistance that we received from the many agencies who stood with us in our pursuit of justice, including the enforcement bodies I just mentioned, the Commodities Futures Trading Commission, the Office of the Comptroller of the Currency, and the Financial Conduct Authority in the UK, as well as the Securities and Exchange Commission and the Federal Reserve Bank. And finally, I'd like to acknowledge my predecessor, Eric Holder, who oversaw this investigation from its inception. His relentless work made this resolution possible, and I want to thank him for his commitment to this important work. Now, at this time, I'd like to introduce Assistant Attorney General Bill Baer, who will provide additional details on today's announcement. Thank you.
Good morning. I want to thank the Attorney General on behalf of the women and men of the Criminal and Antitrust Divisions and the FBI for her leadership and support in prosecuting these cases. And we all applaud the great teamwork from the Bureau, from the Antitrust Division, from the Criminal Division that led to the results we are announcing today. We appreciate as well the ongoing cooperation in these cases from the Commodities Futures Trading Commission. Today's guilty pleas to criminal charges represent major developments in our investigation into collusion affecting foreign exchange markets, particularly the spot market for trading U.S. dollars and euros. The antitrust guilty pleas announced today involving four major international financial institutions, Citicorp, JPMorgan Chase, the Royal Bank of Scotland, and Barclays, are without precedent. In light of the seriousness of the crimes and the unjustified benefit to the bottom lines of these banks, we have demanded and secured parent-level guilty pleas, secured record fines of more than $2.5 billion, and insisted upon 3 years of court-supervised probation for each of the pleading banks. The dollar-euro spot market is as big as it gets. Every day, about 500 billion worth of dollars and euros are traded in this market. Trading on the dollar-euro spot market is 5 times larger than all U.S. stock exchanges combined. Simply put, exchange rates are prices to buy and sell currency. They should be set competitively, the same way prices are set in any market. Instead, the members of this cartel chat room conspired to gain unlawful profit by manipulating those exchange rates. The banks pleading guilty today are not just ordinary market participants. They are market makers. They represent 25% or more of dollar-euro exchange rate transactions each year. As such, they were uniquely positioned to manipulate this market. And that is just what they did. First, they agreed to rig the 1:15 p.m. and 4 p.m. fixes. These fixes are designed to be snapshots of the euro-dollar exchange rates at a given point in time, reported by unbiased third parties. The snapshot rates become the price paid for billions of dollars of currency bought or sold on any given day. The cartel conspirators used chat room communications in the minutes and seconds leading up to those snapshot moments to move the fixed price in the direction that would be most profitable to them, thereby cheating customers who relied on those fixes to fairly reflect market rates. Second, members of the cartel also hatched plans in the chat room to protect the conspiring banks at other times during the day by agreeing to hold off buying or selling dollars and euros. By not trading at these times or standing down, members of the cartel minimize price movements and help each other close out of their open positions profitably, once again, at the expense of customers and counterparties who expected and were entitled to receive a competitive dollar-euro exchange rate. It is imperative that these banks accept full responsibility for these bad acts and carry through on their commitments to change the culture that allowed this behavior to go on for years without detection. That is why we have insisted on parent-level guilty pleas, record-level criminal penalties, ongoing cooperation with our investigations, and a probation period of 3 years, during which each bank's efforts to implement effective compliance programs will be closely monitored. Again, my thanks to the hardworking team that produced the results we are announcing this morning. Let me now introduce the head of the criminal division, my friend, Assistant Attorney General Leslie Caldwell. Thank you.
Thank you, Bill. The guilty pleas of these 5 major financial institutions from the United States and from overseas really are historic. The guilty plea to be entered by UBS in particular results from the bank's breach of its non-prosecution agreement with the department that it entered into in December of 2012. It breached its non-prosecution agreement by engaging in additional criminal conduct, which is part of its non-prosecution agreement it agreed that it would not do. Because of its breach, UBS will plead guilty to felony wire fraud for its LIBOR-related conduct and will pay a $203 million criminal fine. In December 2012, UBS admitted that it engaged in a criminal scheme to manipulate LIBOR and other benchmark rates, and it paid at that time a $500 million criminal penalty. It entered into the non-prosecution agreement, which I mentioned, and which required it as a significant term of the agreement to commit no additional criminal violations. Unfortunately, UBS did not sufficiently mend its ways. UBS's criminal conduct in the benchmark interest rate markets was followed by additional criminal conduct in the foreign exchange markets. After signing the LIBOR non-prosecution agreement, UBS engaged in fraudulent and deceptive currency trading and also in fraudulent and deceptive sales practices in the foreign exchange market, and it also colluded with other banks in the foreign exchange market, as Bill alluded to. Other factors led to the department's determination that UBS was in breach of its agreement. UBS's compliance program and its remedial measures following the discovery of the LIBOR manipulation did not detect the collusive and deceptive sales conduct in the foreign exchange markets. Its conduct in the original LIBOR matter, for which it initially was not prosecuted, in part because of representations that it made to the department about enhancements to its compliance program, its LIBOR conduct was more serious than that of any other bank. Most significantly, though, unlike the other banks, UBS has a rap sheet that simply cannot be ignored. Within the past 6 years, the department has resolved 3 criminal investigations of UBS, each time resulting in a non-prosecution or deferred prosecution agreement. UBS has also, in that same time frame, entered into civil and regulatory settlements in connection with its sales practices on multiple occasions. Enough simply is enough. Pursuant to the terms of the plea agreement that it has signed, UBS now must implement an institution-wide compliance program that's designed to protect violations in the foreign exchange and benchmark rate markets. The department is also, as Bill alluded to, asking the court to impose a 3-year probationary sentence on UBS, during which it will be supervised by the court and will have to report on progress in its compliance program. Since the LIBOR resolution, UBS has made some progress, but it has not made enough. And this agreement today will require them to enhance and accelerate their progress in the compliance space. Barclays, too, was the subject of a LIBOR NPA with the criminal division, and it also engaged in collusive conduct to which it will be pleading guilty. The department is requiring Barclays to pay $60 million in an additional fine on top of its antitrust plea because of its violation of its prior NPA. But for several reasons, we are exercising our discretion not to prosecute Barclays for the underlying LIBOR conduct. Among other things, Barclays has agreed to plead guilty to the collusive antitrust conduct. It's agreed to plead at the parent level, and it's also agreed to pay a significant $650 million fine. In addition, Barclays has agreed to very specific remediation. These parent-level guilty pleas that we're announcing today really communicate loud and clear that we will hold financial institutions accountable for their criminal misconduct. And importantly, we will enforce our prior agreements with these institutions and other companies. If it's appropriate and proportional to the breach, to the misconduct, and to the company's track record, as the Attorney General said, we will tear up a non-prosecution agreement or a deferred prosecution agreement and prosecute the offending company, as we're doing with UBS. But we will, as we're doing with Barclays, also exercise our discretion to take other actions where appropriate. NPAs and DPAs continue to be valuable tools. We will continue to use them, but we are going to require that parties that enter into those agreements live up to the terms of those agreements. We are committed to dedicating and prosecuting financial fraud, and we will continue to do so. These are just the latest in our ongoing investigations into manipulation of the foreign exchange and benchmark interest rates. As you all know, to date we've charged 12 individuals in connection with LIBOR. 3 of them have pled guilty, and the banks that are pleading guilty today are required to cooperate in those ongoing investigations, and those investigations are continuing. I want to thank the team, the LIBOR team, the FX team, many of whom are here, and many of whom are also part of the LIBOR team, from the Criminal Division's Fraud Section, from the Antitrust Division, for prosecuting and investigating this very complicated and sophisticated case. I also want to thank the agents, the accountants, and the financial analysts at the FBI for their fantastic work in both the FX and LIBOR cases. And I'm grateful to the Criminal Division's Office of International Affairs, the Commodities Futures Trading Commission, the UK Financial Conduct Authority, the SEC, and the UK Serious Fraud Office for their assistance. And thank you. And with that, I'll turn it over to the Assistant Director in charge of the FBI's Washington Field Office, Andrew McCabe.
Thank you. Good morning. My name is Andrew McCabe. I am the Assistant Director in charge of the FBI's Washington Field Office. As the Attorney General has explained, today's resolution represents the results of a 19-month investigation into manipulation of the foreign exchange market. The criminality occurred on a massive scale, as individual traders at the bank communicated in code in exclusive chat rooms to set price fixing on a daily basis. Simply put, the activities of these traders undermined transparent market-based exchange rate that serves as a critical benchmark to the world economy. Consumers, including companies, large corporations, investment firms, pension funds, based their financial decisions on this market and ultimately made those decisions based on rigged rates. The foreign exchange market is largely decentralized and is lightly regulated. So with no central transactional exchange, the FBI was forced to reconstruct the fraudulent activity from a sea of data. This was a monumental task. In order to recreate the price fixing, the Washington Field Office brought together experts in fraud investigations, including special agents, forensic accountants, and analysts. We essentially took the pieces of a massive jigsaw puzzle and assembled a picture of manipulation. This type of analysis in the foreign exchange market by law enforcement is unprecedented. In close coordination with prosecutors and regulators, the team reviewed more than 680,000 pages of financial records, conducted more than 175 detailed interviews, and reviewed more than 1 terabyte of complex bank trading data. As a result, the work revealed the collusion by traders, the subsequent anomalies in the market, and ultimately the bank's culpability for this manipulation. This crime crossed international borders and demanded that we too cross jurisdictions to closely coordinate with partners abroad, particularly in the United Kingdom's regulatory law enforcement authorities. Our legal attaches in foreign countries around the world help facilitate this close cooperation, and for that assistance we are grateful. This investigation shows that the FBI can and will continue to investigate the most sophisticated criminal activity. The advances in digital analysis developed by this team is now used as a model by other FBI agents around the country working on similar complex cases. At its core, the case comes down to the criminal activity of a few individuals at some of the world's largest banks who manipulated the market for their own personal benefit. No level of criminal activity, no matter how complex, is beyond the reach of the FBI to investigate and bring those responsible to justice. I'd like to personally thank all the members of the investigative team at the Washington Field Office for their diligence and perseverance in seeing this case through. I'd also like to thank our partners, first and foremost at the Department of Justice, and also the men and women of the CFTC, the SEC, and also the Federal Reserve for their incredible assistance and cooperation in this matter. Now I'd like to turn over to Director Aiton Goldman of the Commodity Futures Trading Commission's Division of Enforcement. Thank you.
Thank you. On behalf of CFTC Chairman Tim Massad and the other commissioners of the CFTC, I want to thank Attorney General Lynch, former Attorney General Holder, and the team here at the Department of Justice. I began my legal career in this building, so I am personally gratified by the extraordinary assistance and cooperation on these matters that we've received from the Department of Justice, including the Criminal Division, Antitrust Division, as well as the FBI. I also want to thank the dedicated and talented staff of the Division of Enforcement of the CFTC, who have been working on benchmark manipulation cases for 7 years now, beginning with the LIBOR investigation. With today's actions, the CFTC has brought 15 cases alleging benchmark abuse and collected over $4.6 billion in fines. Today, we are announcing 2 significant benchmark settlements. First, Barclays has agreed to pay a fine of $400 million for attempting to manipulate and false reporting related to foreign exchange benchmark rates. This brings the total fines obtained by the CFTC for foreign exchange benchmark manipulation to almost $1.9 billion. Further, today we are announcing our first settlement of a 3rd major benchmark manipulation investigation. In addition to Barclays' settlement of our foreign exchange case, the bank has also agreed to pay $115 million for attempting to manipulate and making false reports relating to the ISDAFIX, a leading benchmark for interest rate swaps and related derivative products. The ISDAFIX rate that Barclays attempted to manipulate is used for valuing cash settlement of interest rate swaptions and a wide range of other financial products. These cases of benchmark manipulation go to the very core of the CFTC's mission of ensuring the integrity of the markets that we regulate. There is very little that can undermine faith in market integrity as quickly and completely as when some of the world's biggest banks attempt to increase their own profits by manipulating benchmark rates that are relied on by companies and individuals around the world. Our pursuit of benchmark manipulation started with the LIBOR investigation, but it did not end there. Having seen the misconduct in the setting of the LIBOR and foreign exchange benchmarks, and now in ISDAFIX, we will continue to aggressively look at benchmark integrity. So the American people should know that their government is on the case and will be until the public can have confidence that these benchmarks are set fairly and that they are not corrupted by manipulation by insiders and big banks intent on profiting from their own roles in setting these rates that are used by so many. Thank you.
Thank you, Aiton, and all of our other speakers. Are there any questions?
Ms. Lynch?
Yes. Hi. Yes, less than 3 years ago, a number of these same banks were charged with manipulating LIBOR. Today, currency rigging. At least one bank has already disclosed an investigation into metals. Where does it end, and what does it say about our financial industry?
Well, I think that when you look at the exchange markets, as has been noted before, they are very lightly regulated. And so it is incumbent upon law enforcement and our regulatory partners to have a sharp eye out for attempts to manipulate them. Where it ends with respect to the Department of Justice is where it always ends, which is a review of the evidence and a view as to where criminal liability can be found. As you noted, we did have a number of settlements in the LIBOR matter. One of those entities, one of the largest offenders in the LIBOR matter, is now being required to actually plead guilty to that behavior because in order to get that non-prosecution agreement, they made certain representations which they have let fall by the wayside in a very, very significant way. So we're continuing the investigation into the FX markets. That matter is ongoing. Certainly, as CFTC has noted, other markets are being looked at and reviewed as well. We will follow the facts and evidence wherever they lead.
What is the significance, you mentioned several times about the parent level guilty plea. What's the practical significance? It sounds very ominous, but what does that mean in practical terms?
Well, I think certainly it means that the entire institution was affected in a very systemic way by this behavior, which leads us to seek a parent-level plea as opposed to focusing just on a subsidiary, which sometimes you do see if the behavior was limited in a certain way or confined to a certain small set of actors or actions. But this behavior by traders who were very senior, who were acting on behalf of the parent banks, which enriched the parent banks significantly, was so systemic and so egregious that we felt the entire institution had to take responsibility at the highest levels. And this is something that you see in some cases, not all. As I mentioned, sometimes you will see a situation where the activity is just sort of limited or cabined off. This was so systemic and impacted the banks so much that the parent level pleas are appropriate. What it also means, however, is that with respect to the probationary period and the reporting requirements that these banks now have, that the parent companies are on notice that if there are other additional criminal activity discovered by them, it has to be reported. That's now widespread. It's throughout the bank. That will all be taken into consideration as we review what to do should there be further misconduct.
At your confirmation hearing, you were asked about charges. At your confirmation hearing, you were asked about charges for individuals. And with these settlements today, we didn't see any individuals charged. How do you hope to deter future misconduct without individual charges?
Well, I think what you'll see with respect to these investigations of very sophisticated markets, starting with the LIBOR investigations, where there were a number of individuals that have been charged, 3 have already pled guilty. With respect to the current matter that we're announcing today, that investigation is ongoing. So I'm not able to comment on whether or not we'll be bringing additional charges against individuals, except to say that the investigation is ongoing and it goes beyond simply just the dollar-euro connection as well.
Regarding the nullification of the UBS NPA regarding LIBOR, that makes them a repeated offender, if not serial offender. How does that affect how DOJ will look at this bank in the future? Are they now in a special category?
Well, I think that what you see is when you look at how we resolve matters with institutions, and particularly when there's a guilty plea involved, should UBS reoffend and they were to face another guilty plea, that would be taken into consideration by a judge in imposing fines and imposing probations. It all adds up, so to speak. But also, as part of this, all of these banks are required to cooperate, and as we have previously discussed, that means disclosing to us any additional criminal conduct that they find. Certainly, we always work with the regulators and provide information to them about matters that we discover, and that would subject them to regulatory conduct issues as well.
I think we were told 12 individuals charged, and I'm just wondering if the people who are in this cartel have been arrested and charged, and will there be more arrests?
So the 12 individuals that were referenced today are with respect to the earlier LIBOR investigation. 3 of those individuals have already pled guilty, and the cases against the others are ongoing. There are also individuals who were charged overseas by Great Britain in respect to the LIBOR investigation. With respect to today's announcement for the FX investigation, I'm not able to comment on the status of the individuals who are involved, except to say that the investigation is ongoing.
How many people were in this cartel? Any idea? Was it dozens of people or just a handful of individuals?
Let me refer that matter to Bill.
Thank you. Each bank participant had a senior currency trader who oversaw a whole bunch of other traders, and that was the vehicle by which these banks were able to participate in the cartel through the use of an online chat room.
It's dozens of traders, bank employees?
As the Attorney General said, we're not prepared to announce further facts and details at this point. This investigation is ongoing.
Ms. Lynch, so today the U.S. government released a number of documents related to bin Laden, the documents that were taken at his compound. Wondering if, since you've been Attorney General, are you still hearing a lot about bin Laden in your briefings, or sort of have the ISIS and online propaganda taken over your briefings?
You mean in the confidential briefings that we don't talk about? Those? I think what I can certainly say is that with respect to the Department of Justice's review of national security matters, as well as our government's review, that we're looking at all actors in this. We certainly are looking at ISIL. Certainly they have been very active in social media and publicly, but we by no means are discounting any of the other actors who have been very, very visible and have made threats against American interests, and that would include Al-Qaeda and its many variants.
What banking operations, if any, are affected by today's resolution? And will they have to obtain any kind of waivers to continue operation?
Well, my understanding is that they have to deal with their regulators, who are numerous and varied, and that the banks have been working independently with those regulators to determine whatever waivers might be required for them to continue to operate.
The DOJ is saying enough is enough, but UBS only has to pay $203 million for the LIBOR guilty plea. Could you give us some insight into how you came up with that number?
Well, I can have one of my colleagues talk about how we calculate the fines in a moment, because it is really based upon a formula involving, for example, how long they were engaged in that. But what I can also say is that in addition to pleading guilty to the LIBOR conduct, for which it had previously received a significant benefit, UBS is also admitting its behavior in this FX conspiracy as well. So they are admitting their fraudulent behavior and their collusive behavior regarding to the FX market as well. And so with respect to the fine calculation, there is a formula that we use, and I'll turn that over to Leslie Caldwell to go into that.
So as you can see from the paperwork, the fines are different for every bank, and that's because they're based on the duration of the conduct for each bank, which varied from bank to bank. As to UBS, the fine is really based more on its LIBOR conduct. It already paid more than $500 million in connection with its prior resolution of LIBOR, and that represented a discount from what it might otherwise have had to pay, but for the fact that it was getting a non-prosecution agreement. So this $200 million basically erases some of that discount.
And who is not?
Yeah, I mean, you've got criminal guilty pleas this time around. The banks, though, have sought waivers so that it has a minimal impact on their businesses. And the UBS fine is a lot lighter than many people had expected. And we have seen in the past that fines hasn't seemed to deter future misconduct. So how do you really stop these settlements still being seen as a cost of doing business for these banks?
Well, I can tell you that having to enter into a guilty plea at the parent level by a major financial institution is not something that they enter into lightly, nor something that they enter into with any great joy in their hearts. And so I think that with respect to how we deter future behavior, we continue to exact significant penalties here, up to and including guilty pleas from banks. You know, we're looking at a situation where a number of major financial institutions have been able to resolve various matters with the government with either non-prosecution or deferred prosecution agreements. Those carry significant benefits. The avoidance of a guilty plea and any collateral consequences is a significant benefit to any institution, financial or otherwise. A guilty plea certainly is something that they seek to avoid, and something that is definitely on the table for institutions that have those agreements with us. In addition, as has been previously said in other forums, we are requiring cooperation from these banks up to identifying for us individuals who were involved in criminal behavior, whether it's the FX issue or other issues that they may be aware of, and we certainly will be scrutinizing them very, very carefully and pursuing those options as well.
Yes, on UBS again, in these 3 years probation, they have to implement the compliance program, but will you check back on that? Will you supervise the program? Will you see that it is working? And what penalties do they risk if it is not?
Yes, with respect to UBS's 3-year probation, there are very strict compliance terms there. They will be reporting to the court and to the Department of Justice periodically their efforts in compliance, particularly since for UBS, one of the reasons they find themselves in this situation is their prior representations of an outstanding compliance program that simply was not working in that way. So they will have to report periodically on this, and we will be monitoring them very, very closely.
I'd just like to follow up on the waivers question, if I may, because that has come up in previous settlements with these banks. Can you elaborate on any discussions about the waivers that took place as part of the settlement? It raises even concerns for members of Congress about whether these settlements have teeth if those waivers are granted.
Well, any sort of waiver would have to be granted by a regulatory institution that also has oversight authority over the financial institutions here. Everyone has their own rules and ways in which they review these. We certainly work closely with our regulatory partners. We provide them with the information they need to make their own determinations as to whether a waiver may or may not be appropriate in a particular instance. But it's their decision.
Regarding the ongoing DOJ program for Swiss banks regarding the tax evasion issue, we expect a lot of non-prosecution and deferred prosecution agreements there. There's a dozen or so Swiss banks that are under investigation. Given what we heard today, does this change DOJ's approach in any way, in particular when it comes to the requirement of guilty pleas?
Well, I think what you see today is DOJ's approach that we will look at the evidence and facts in every case, and where we think that a guilty plea is appropriate, particularly based upon past misconduct and prior representations to the government, we will look to exact guilty pleas. We will always look at every case individually. We'll always listen to every bank's arguments or every company's arguments as to what the appropriate penalty may be. We will always give them a forum in which to express their views, but we will always consider every range of penalties.
Do you have a time frame for this tax evasion issue, when it will be resolved with all of the Swiss banks?
I'm not able to comment on that.
Fines themselves, will they be paid to the general U.S. Treasury, or do some stick to the Justice Department?
These fines do go to the Treasury, and where they are part of the funds that are used to fund victims' compensation as well.
All right, thank you. That concludes our question.